We have, again, sort of our weekly announcement that we're doing away with introductions, but certainly for our first speaker of the evening to deal with Provincial Offences Act appeals, if you don't know His Honor Judge Dnieper, it means that you haven't practiced criminal law or certainly haven't been in the provincial courts in the Judicial District of York. Our first speaker.
Thank you, Brian. The Provincial Offences Act of 1979 was given royal assent to on April the 1st of 1979. The Act and its importance can best be characterized by a quote from the very excellent textbook Ontario Provincial Offences Procedure by Doug Drinkwalder and Doug Ewart, both Crown attorneys, if I may quote. The Provincial Offences Act is one of the most sweeping legislative reforms of the procedures governing the prosecution of offences since the enactment of Canada's first criminal code in 1882. It marks the first time in modern history that the Ontario legislature has fashioned comprehensive procedural provisions to govern the prosecution of the offences it has created. And indeed, it represents the first attempt in Canada to create a procedural framework which at each stage recognizes and responds to the important distinctions between provincial offenses and true crimes. The intent of the legislature, in fact, was twofold. Firstly, the Act reflects an acceptance that provincial offenses are perhaps civil in nature. The framers of the Act, bearing in mind a case no doubt you're familiar with, Re Abitibi Paper, 1979, 47 Canadian criminal cases, second series, 487, the decision of the Ontario Court of Appeal. It's interesting to note that Drinkwalder and Ewart almost categorically state that the decision was wrong, although both of them had quite a part to play in the framing of the Act. The Sault Ste. Marie decision seems to be somewhat at odds with the Abitibi case as well, however that may be. The second intent is described in the explanatory booklet issued by the Ministry of the Attorney General in 1978, where it is stated that the object of the Act has been to create, and I quote, a new procedural framework stressing convenience, clarity, efficiency, and simplicity. My own experience has been at the trial level, the convenience, the clarity, the efficiency, and the simplicity is all the prosecutions. Although I must say that at appeal, I think the defense has the edge. When this act was proclaimed, the machinery for the Provincial Offences Appeal Court had to be set up. None of us knew either the number or the nature of the appeals that would be coming before the court. The chief judge had in mind that we would open 3 courts to hear the cases coming from the metro region of the Judicial District of York, but I suggested that perhaps we might start with 1, see how the matter progressed, and we may save the taxpayers quite a bit of money. In the year and a half that I have been sitting in the Provincial Offences Appeal Court 3 days a week, I have disposed of somewhere between 4,000 and 5,000 cases. As it turned out, almost every case required the breaking of some new ground and entailed, in my view, as much work as anybody could ever be required to put in on a government salary. His Honor, the Chief Judge, considering that I may be bored through lack of activity, hearing only 120 appeals a week, permitted me to spend the other 2 days hearing privately laid criminal charges and all the information laid for the various government departments under Part 3 of the Act. then after taking my usual Saturday morning turn in the provincial courts, I'm afraid my family saw very little of me during that period. I was determined on one point. There was to be no backlog whatsoever in that court, and there isn't. Prior to coming here, I checked the file cabinet, and there are 51 appeals. That's all. It's all the backlog there is. That can be dealt with in 2 days. The first necessity was to provide some sort of code of procedure. Over the months, the procedure was adopted that was almost identical to the procedure in the Court of Appeal, subject to several provisions contained in the Provincial Offences Act and in the Provincial Courts Act, which was made a companion piece by the 1979 amendment. In addition to producing the Code of Procedure, these 4,000 cases as well showed up some large number of serious weaknesses in provincial legislation. Some of these matters went to appeal to the Court of Appeal, but there was only one case which the Court of Appeal changed the decision, and that was at my specific request because the law on the point was, in my view, evenly divided. Now, to provide any sort of comprehensive academic discussion of appeals under the POA in 40 minutes would obviously be an impossibility, so I propose a short discussion geared to the practical requirements of the practicing solicitor. If you wish to go into the matter further, I can recommend strongly the Ontario Provincial Offences Procedure book by Drinkwalder and Ewart, together with consideration of that great body of procedural law used in argument before the Court of Appeal. Whilst a large number of these appeals are taken by defendants themselves without the aid of a lawyer, a surprising percentage are argued by counsel. I think your involvement with the POA appeal procedure will be on behalf of corporate clients running afoul of provincial regulatory bodies operating under provincial acts that might be described as minor, but are of extreme importance to the client in that particular business. For example, a charge arising under the Public Commercial Vehicles Act may carry a fine of $100, but it might also result in your client losing his license, which is worth somewhere in the neighborhood of $80,000 or $100,000. Or you may appear perhaps for a client running afoul of property bylaw provisions, or for clients who have lost their driving licenses by reason of demerit point accumulations, or for clients who have somehow been involved in road accidents and concerned with insurance, or perhaps for clients who feel they are right and just want to prove themselves so. Before I discuss the appellate procedure, perhaps I could advert to the trial provisions of the Act. Charges are streamed in 3 lanes under 3 parts of the Act, headed, strangely enough, Parts 1, 2, and 3. Part 1 offenses are charged and process begun by the issuance of a certificate of offense and delivery to the accused of an offense notice. The policeman does this on the spot. Part 1 procedure can be utilized only by a provincial offenses officer and cannot be used by a private complainant. Part 2 governs parking offenses. For whatever reason, the legislature decided not to proclaim and enforce this part of the Act until April 1st, 1982, so that we have the anomaly that provincial offenses of a minor nature are begun by the issuance of a certificate of offense, but parking infractions, which to me are still more minor, are processed through the provisions of the Summary Convictions Act of Ontario, embodying Part 24 of the Criminal Code. However, after next April, both parts will be the same. Part 3 procedure was designed for the more serious of the provincial offenses and certainly for those offenses that carry a penalty over and above the $300 limit set out in Section 12 of Part 1 procedure. Part 3 is begun by the issuance of an information. I don't think the system has worked out completely as the legislature intended because, for example, the police use Part 3 procedure often enough, for example, to prosecute illegal turns at an intersection. This is because they wish to take advantage of the longer limitation period for a Part 3 process. When I made inquiry of the police as to why they did this, the answer by the witness was that when he was standing on the corner observing traffic, the book of offense notices made too much of a bulge in his pocket. The department wished to save the cost of providing him with a car. I didn't think this was in the spirit of the act. I allowed the appeal and criticized the practice in strongest terms. I'm given to understand that the department has cut out that nonsense now. Appeals are governed by Part 6 of the Act. All Part 1 appeals, those appeals started by the offense notice, are heard by a provincial court judge of the criminal division in the Provincial Offences Court. Part 2, the parking offense appeals, are now supposed to be heard by the county court, but very shortly, of course, will be heard by the provincial court in line with Part 1 procedure. Part 3 appeals are heard by a provincial court judge if the trial was before a justice of the peace, but by the county court if the trial was by a provincial court judge. The logic of this rather escapes me, especially since, for example, convictions for contempt in our courts under Section 16D1 are appealed to another provincial court judge. But if that's how the Legislative Assembly wanted it, so be it. Your appeal will go to what is known as the Provincial Offences Court, or rather the Provincial Offences Appeal Court, set up by the Provincial Courts Amendment Act. Now, this act did four things. It created provincial offences courts, including the Provincial Offences Appeal Court. It made the Provincial Offences Court a court of record. It provided for rules of court to be set by the Rules Committee by way of regulation, and most importantly, I think, it left procedure largely in the hands of the judge. If I may quote Section 9, subsection A of the amending act, where jurisdiction is conferred on a judge, justice of the peace, or provincial court, in the absence of express provision for procedures, therefore, in any act, regulation, or rule, the judge, justice of the peace, or provincial court shall exercise the jurisdiction in any matter consistent with the due administration of justice, whatever that means. This seems to me to be really a vote of confidence in your judges, but it also puts an awful burden on us all. The ministry stated that this power is a, quote, narrow one, intended to fill any hole left by the act. But as you will see, on appeal, we have been in fact left largely on our own because the act leaves very, very much unsaid. And it was under this section that most of the precedents for procedure on appeal were set. Presuming your appeal is to the Provincial Offences Appeal Court, what do you do? First, tell your client to pay the fine. Section 95, sub 1 requires this. If your client can't pay the fine, either by reason of inability to pay or for some other good reason, get an application for recognizance and waiver under Section 95-2. Now, these must be taken in court, but as a practical matter, the clerk takes it from you and passes it up to the judge, and the judge just signs it. In fact, I can't ever recall such an application being refused. Secondly, you must bear in mind that once there is a conviction registered, the conviction stands. So that if the conviction is of any inconvenience to your client, for example, if he's lost his license to drive because of it, you can get a stay of conviction from the judge. Section 96 provides for this. Now, I've never had an application for a stay of conviction, but who knows? It may sometime be necessary. Now, there's no printed form for this, and I'm sure any wording will do, but I would suggest that you just go over to the office and get a handful of the general order forms from our appeal office and keep them around. They're very useful, actually. Thirdly, get the printed appeal forms from our appeals office on the ground floor of Old City Hall, room 15, and just fill out one. I'm sure the office would be happy to give you as many as you like. Take home an armload. Save your secretary a lot of typing. If it's a Part 1 appeal, it will be Form 201 under Regulation 201-1980. If it's a Part 3 appeal, Form 301 under Ontario Regulation 202-1980. So in actual practice, the Part 1 form is used for all appeals. In fact, any sort of application will do. You can write it out, type it out, scribble it on a napkin for all we care. All that's necessary in the appeal is that you state who is appealing, what is being appealed, the conviction, the acquittal, or the sentence, and that's to limit the court in its jurisdiction, the date of the trial, and that's so we can find the tape or the transcript, and who the respondent is, and that's so that we can send him notice of the appeal. You'll also have to put in your grounds for appeal. Now, any ground will do, and it's merely a convenient notice to the judge that he should look for this, that, or the other when it's being argued. You needn't concern yourself about it because any ground at all can be argued on appeal, whether it is pleaded in the notice of appeal or not. Now, please note that under Part 1 appeals, it's the court clerk that sends the respondent the notice of appeal. But under Part 3 appeals, you have to serve the notice and you have to file the affidavit of service. Once you file the notice of appeal, one of the very charming, actually, young ladies at our office will ask you when you would like to be heard. On any Monday, Thursday, or Friday, completely at your convenience. There is a requirement for a 15-day notice to the respondent, but Crown has universally waived notice. In practice, if you file your appeal in the morning, it can be heard that afternoon. In spite of the workload, we have no backlog, and as long as I have anything to do with it, there never will be either. That's all there is to the launching of the appeal under the POA. When you appear at the appeal hearing, the papers will all be there, the tape of the transcript will be there, but a transcript won't be. Part 3 appeals require a transcript to be filed by you. That's under Regulation 202, Section 16.1. Though I must say that requirement is usually ignored by the court. If the tape is available court will accept that. But bear this in mind, please. If there has been an accident involved, there isn't going to be a tape because, for reasons best known to the administration, they don't take tapes of accident traffic cases. They have a reporter there. Now, it's more costly, and I don't really see the necessity for it, but apparently that's the practice, and we all have to live with it. Now, you don't have to concern yourself about the paperwork or time constraints or technical imperfections, because the court invariably makes all necessary curative orders to allow you to argue the merits of the appeal, which I think is the aim of the Act. Indeed, if I may quote Mr. Justice Brooke in a case, the Queen against Salhany, he said, "The purpose of the Provincial Offences Act was to simplify and expedite the hearing and disposition of provincial offenses, and it is very important in terms of both cost and time to the individual charged and to the administration of justice in our community that this be achieved." Indeed, the rules permit you to make application to the court for directions as to perfection of the appeal, and it's mandatory on the court to give you such directions and aid. At the appeal hearing, you can ask the court to listen to the tape, or you can have your transcript. My experience has been that counsel usually have the transcript, probably more for their own use than for the convenience of the court. And if you're ordering a transcript, as you know, I don't think you're going to get it in less than 4 weeks after ordering it. In any case, after hearing you, then hearing counsel for the Attorney General by way of intervention, and the Attorney General always intervenes, the court will, of course, give the decision. My own experience is that counsel win most appeals, except cases of careless driving, and they lose most of those. Now, who may appeal? Sections 93 and Section 118 provide that only the defendant, the prosecutor, or the Attorney General by way of intervention may appeal. This provision has some important consequences. For example, the City of Toronto cannot appeal any decision on its own bylaws. Bylaw prosecutions are laid under Part 3 by an informant, and the Corporation of the City of Toronto cannot appear on the appeal. What they do is they pay for counsel to appear on behalf of the informant who works for the city anyhow. So perhaps it's academic, but it's there. Ministry of the Crown can't appeal. The Attorney General's man has to. Who responds? Only the defendant, the informant, or the intervening Attorney General, or their agents or counsel. In the usual case, it's going to be a man named Shakur Manraj, one of Her Majesty's counsel, learned in the law of Middle Temple. Mr. Manraj is not a member of the Bar of Ontario, but he is an English QC and a pretty good man in court. You will find that he's very courteous, very helpful, very cheerful, and if you don't have a good case, and if you're not prepared, he's going to do a pretty good number on you. Now, when can you appeal? The time limit for Part 1 appeals is 15 days under Section 118, and is 30 days for Part 3 appeals. It's under Section 8 of Ontario Regulation 202. If you're past this time, don't let it concern you. The bulk of appeals are brought in after time has run out because the accused doesn't get notice of his conviction until well past appeal time has run out, especially when the conviction is under the provision of Section 9. Leave to appeal after the time limit is granted under Section 85, and so far as I can recall, it's always granted if there's any reason at all for it. There is no form in the rules, but the office will give you a handful of mimeographed applications. As a matter of fact, I brought down some few hundred for you. It will be noted that leave has to be granted in open court, but in practice, just bring it to the office and they'll send it up and it'll be looked after for you. Now, what can you appeal? Ignoring the mental capacity problems, you can appeal a conviction, an acquittal, or a sentence. I advert your attention to Section 93 and Section 118. Please bear in mind you cannot appeal an order. The one exception to that is the order as to costs. That can be appealed because costs, even costs made against a prosecutor, are collectible as a fine under Section 61(3), and as such have been held to be in the nature of a punishment and appealable. The purchase case, some authority on that. Please bear in mind you cannot appeal a finding. Now this is important in my view. If I may digress for a moment. I believe that fully 3/4 of the license suspensions in this province are illegal. And perhaps one of you might see fit to test the procedure of the suspension of licenses under the demerit point system. Most of the suspensions under the demerit point system are for speeding, as you very well know. When the justice of the peace convicts, he merely convicts the accused for exceeding the speed limit under Section 82 of the Highway Traffic Act. He does not convict the accused for exceeding the speed limit by any certain amount. This I believe to be the law, and if I may, with your permission, quote learned county court judge in Amyot, A-M-Y-O-T, against Her Majesty, 1968, 4 Canadian criminal cases at page 58. I think this view of the law would stand up. Now, the Highway Traffic Act regulation, that's Regulation 413 of the 1970 Revised Regulations of Ontario, requiring the registrar to ascribe demerit points in accordance with the schedule, speaks only of a conviction in Section 2. The particulars of the charge cannot affect the regulation, and here, in my view, is the key. Neither can a justice of the peace's finding of fact on which he bases the conviction. His finding of fact is not the conviction. My own view is that the regulation requiring demerit points to be ascribed is ineffectual, and I believe that an application for extraordinary remedy to divisional court for mandamus or prohibition, as the case may be in order. I have no doubt that the order will be granted and most license suspensions will be made invalid. But if I may again quote Mr. Justice Brooke, we are not unsympathetic to the position of the Crown. However, our role is to observe and apply the statute as it is written. Part 6 is divided between appeals under Part 3 and appeals under Part 1 and 2. But to make any reasonable sense of all of these sections, it's been held, applying the Interpretation Act, that all of these sections apply to both parts where it is reasonable to do so. The biggest problem we had was that Part 1 appeals were to be, quote, by way of review, Section 119. But there was no such direction relating to Part 3 appeals. I accepted the proposition that all appeals in the Provincial Offences Appeal Court should be heard in the same manner. I could not buy the idea that because a provincial offenses officer chose process by way of information under Part 3 rather than by way of certificate of offense under Part 1, the appeal had to be by different rules. The question was, what is review? Could the appeal court hear or read the record and substitute its opinion as if it were a trial de novo? After canvassing other usages of the word review, I concluded the court could not. I considered the word's dictionary definition, both in the dictionaries of English usage and dictionaries of legal words and phrases. I considered its use in sentence review, in taxation matters, in Section 124, in federal statutes, and in Section 457 of the Criminal Code relating to bail. On that last point, I found the decision of Madam Justice Van Camp in an unreported decision in the Queen against Dubois most helpful by way of analogy. Dubois contains a comprehensive compilation of authorities in that regard. I won't bore you by citing the numerous cases contained therein, but if you'd like them, I'd be happy to send the decision to you. I felt Madam Justice Van Camp's ultimate sentence in Dubois to be helpful. I quote, "As to the procedure that is to be followed, I adopted the decision that it is the obligation of the accused to review an order already made. It is for him to put whatever evidence he wishes before me under 7. After I have heard that evidence, I will then hear whatever the Crown proposes to put before me, and full opportunity will be given to the accused in reply to contradict any evidence he considers prejudicial." Now, very loosely, this seems to be in accord with the view taken by the learned text writers Drinkwalder and Ewart. They state at page 359 on this point, I quote, "Instead, it is apparent that the review is to resemble a review on the record, with the court being given abundant powers to ensure that the record is complete because the appeal is not a trial de novo. The onus will be upon the defendant to on appeal to convince the court that he ought to succeed. The onus does not revert to the prosecution to reprove his guilt." I have accepted this view. To presume otherwise, I believe, is to contravene the doctrine of finality of judgment. This was spoken of by Mr. Justice Urquhart in a case called Nelligan against Lindsay. It's in the Ontario Weekly Notes, I think 1964, and I've forgotten the page. To presume otherwise would mean that any appeal was a trial de novo, partially perhaps on the record, but would make useless the trial. Now, it's often been stated, a trial is just that, a trial, not a trial run. When you argue your appeal, you will have to show error. You will have to show that credibility findings were unreasonable, that findings of fact were perverse. However, to aid you, the Act provides that new evidence may be accepted. This, of course, cannot always be the case. There are precedents governing it. But you must show some reason why it was not brought at trial. This is to prevent serial defense or serial prosecution. Serial prosecution. This may sound very strange to you, but the Crown did in fact try it once. They put in half a case, let it go, appealed the acquittal, wanted to put the rest of the case in. I pointed out the inequity of the procedure, had a few choice words to say to learned counsel for the Attorney General, and they never did it again. The practical reason for this view, of course, witnesses won't come to court twice for the same fender bender. Now, what relief can you get? The appeal court can quash the conviction or can direct a new trial. My own experience is that where there is some merit in the appeal, even if nothing more than a new trial is indicated, usually the conviction is quashed so that the citizen might be saved the trouble of multiple appearances before the court. The Crown's never complained. As a matter of fact, I was talking to Miles Halberstadt before we came in. The only thing the Crown complains of is appellants lying to the court. In every instance, absolutely, perjury charges are laid. And they've got 8 men in jail arising out of illegal left turns or speeding of 10 miles over the limit. Miles prosecuted one of those cases and got 2 months for his man. Made an illegal left turn and did 2 months for it. Where only a police officer is involved, a new trial is usually granted literally at the drop of a hat. I've always felt that if a citizen is concerned enough about the conviction and there's some merit in it, consideration should be given him. On the other hand, where there are citizen witnesses concerned, the rules relating to trial error are more strictly observed. Where do you go if you don't like the decision of the judge of the Provincial Offences Appeal Court? I don't think you go anywhere. Section 122 provides that an appeal from the judgment of the provincial court lies to the Provincial Court of Appeal. However, the appeal is on special grounds on any question of law alone in accordance with the rule of court. Leave to appeal must be gotten from a justice of the Court of Appeal, and subsection 2 of that section provides that the justice can grant leave only if he considers that in the particular circumstances of the case it is essential in the public interest or for the due administration of justice that leave be granted. They've granted leave in, I think, 5 cases, all at the instance of the Crown, and bounced the Crown on all 5 of them. So your chances of going to their lordships are almost zilch. Applications by way of extraordinary remedy are preserved by Section 124 under the heading Review. All that does is negate the procedure under the Judicial Review Procedure Act. But you're going to hear more about that later, I'm sure. Before I leave, if I may make one comment as to costs. Section 121.3 gives the court the power to assess costs against either the appellant or respondent in accordance with the provisions of Section 61.3 relating to Part 1 appeals. The limit there is $6.50 for a witness and $1.50 for transportation. Part 3 appeals, the court can make any order that it considers just and reasonable, but I've never seen anything over $8 anyhow, so your appeal is for free. Practically, it really doesn't matter because only in very rare instances are costs ever considered or assessed. My recollection is that I've imposed negligible costs only where a witness has been brought to give testimony on an appeal that was clearly frivolous. In my view, the act is good. It properly reflects the nature of provincial offenses. The appeals are quick, they're free, and statistically, you've got at least a 50% chance of success. The year and a half I spent setting up the court or working in it was extremely interesting. It was challenging. It was a work burden. And I feel I'm entitled to a rest period now. So I think I'm going to go back to the regular stream and just deal with breaking and entering cases and things of that nature. Thank you for your attention.